Dear students, welcome back to Foundations of Law. So I'll be talking a bit about um, certain aspects of Foundations of Law. We're looking at the very first lecture over here in Moodle. So I hope you're all in Moodle already. And well, last time I just spoke in very general terms about foundations of law and the topics we will cover and what I hope to sort of discuss with you. So, carrying on in that stream of thought, I wanted to continue with today's lecture. And well, it seems this coronavirus situation is not getting in control anymore. So, we will have to continue with these online video lecture recordings for the time being. And well, I hope all of you are now registered in Moodle and OIS. So I have added a few articles for today's lecture as well. So what I plan to do is to have a short video lecture and complement that with some additional reading tasks. These are not important from the exam point of view, but hopefully they help give you a clearer picture about the rule of law and the role of law. So, with regard to the lecture, we discussed last time, or rather, I spoke last time about the definitions that one sees in law and the various meanings that these definitions can hold. So, today I'll be looking a bit at the history of law, so the whole legal culture, how it came about. It is actually a story of human civilization and evolution in that sense, because when I was very, very small in school, I remember I was told in the classroom once, or rather I learned about this, no man is an island. Man is a social animal. And of course, when I mean man, it also includes women. And it's an old legal thing. It used to be implied that everything should be masculine and it includes feminine. Although nowadays you see a reversal of this. It's why not you say it in feminine terms, and it's also implies masculine. So again, these are things that law has dealt with in the past and continues to deal with. Gender equality has taken new terms now. So when you look at origins of man-made laws, you can see over here already that some of the first laws that we are aware of were those which came in writing, and that really changed a lot of things, because although laws were always customary in nature, they attained a new meaning because they were now in writing and they were published. And so of course, when it's in writing or it's carved in stone or something, then these tablets suddenly have a more permanence about them, and that is of course something very important, especially when you're looking at the history of laws. So the written laws, we're talking about going back to about 5,000 years, so 3000 BC. And some of the first laws are from Hammurabi of Babylon. And they're very interesting to read, because what you have is the beginning of what we now consider a code. A code is not something purely in the sense of the Napoleonic codes, but it goes more back. And so these are the codes which are in writing. And once they are in writing, then of course that implies that these now have to be followed and dealt with as per the words. So there were some areas that were dealt with even in those times: family law in a certain sense, property law, some aspects of criminal law. So these were of course dealt with, and we can see more about them. But from our viewpoint, the most important aspects would be the developments of Greek law, because these are what you could call the flowering of Western civilization. And so you had some very specific laws, written laws, of course, and so they sort of really helped us to understand how society was in those times. It was not a perfectly, wholesome society. It was not perfect, but they had laws, and these laws had a meaning. But besides the law part, what we understand from the literature of Greek society is that along with the legal aspects, there were the philosophical aspects of law. And so, of course, the questions of what is a person, a legal person, in this case, the definition of a man, and then the definition of a character of law, and leading up to even the definition of law itself. And theoretical questions which still resonate even today. So, is law essentially something that is laid out by a political authority? And in that case, can you have a good law or a bad law? And are man-made laws sufficient? Or are there other laws that are above man-made laws, in which case they would be referred to as natural laws? And at that point of time, society did not differentiate between the religious and the secular aspects. So God, or rather in the Greek case, the gods did get dragged in all the time. And so it was already felt that there are certain laws of nature which are overriding man-made laws. And so there are some examples over here from a Greek story that's laid out. And of course, these are very interesting because the background to this particular story in Antigone is that there was an unjust king who made unjust laws, and so this was the excuse on the basis of which he was overthrown. And the new people who came into power, the new king, then started following the same old habits of creating bad laws. And so the question that comes up now is, you overthrow a tyrant king, and now you replace him with a new king who slowly becomes a dictator or a tyrant in himself. And again, what is important here is the philosophical aspect of law. And just because law is in a book or it's printed, whether that is sufficient to make it legal is the outline over here. So in the Greek nature of things, there was a lot of emphasis on democratic ideals. Of course, in those times, only those people could vote who actually owned property. So there were women could not vote, slaves could not vote. So again, power was condensed in the hands of very few. But there is a legal thought process of Aristotle, of Plato, that is interesting to go into over here. Another aspect, of course, dealt with at that point of time was the question of justice and how everybody should be treated equally. Also important is the relation of corrective justice instead of just merely blind justice. There were already questions spoken at that point of time or discussed regarding degrees of a crime. So you see that even as of today in criminal law procedures or codes of different countries. So for example, if you may recollect, there are all these issues that have been visible on the internet and media regarding for example, colored people, black people being shot dead on the streets of the United States by the police. And this has given rise to a lot of controversies, even movements like Black Lives Matter, etc. And what's interesting from a legal perspective, of course, is that very often the police officer who is charged with a grievous offense, in this case murder, somehow very often gets away with it. They are not punished in a court of law. Now, as students of law, it is important for us to understand why such things happen. Now, this is because there are degrees of homicide, if you may call it so. Now, the wordings may be different in different countries, but this is how it goes. So, for example, let's say I meet you in person and I punch you. So I hit you here, and you know, I don't know how it happens, but your jaw sort of implodes and the force goes into your brain and you die of a brain hemorrhage. I mean, and that's crazy, right? I mean, I'm not a jiu-jitsu master, or I'm not Rambo or Arnold Schwarzenegger or whatever. So how did that happen? Well, it's an accident, right? I punched you, and how was I to know that your whole skull structure, jawbone structure is so weak that everything will just dissolve in one blow? Contrast that with, for example, I meet you in the university and I push you down a flight of stairs. So you just come tumbling down 15 stairs and you hit your head, unfortunately, and you bleed to death internally. Again, a second cause of death. Or thirdly, I take you to the 25th floor of a house in SAS Hotel in Tallinn, and I take you to the top floor where the restaurant is, and I open the window and I push you out, and you fall down 25 floors. Now you see what's happened over here. In the first case where I punched you, the death was unusual. It wasn't really something that could have happened in normal circumstances. Secondly, when I pushed you down 12 stairs, people don't always smash their heads and die. You could break a bone, you could fracture something, maybe get a sprain, but getting killed is quite outlandish. But if I take you to the 25th floor of a house, of a building, and I throw you from the 25th floor without a parachute, chances are 100% you will die. So in all of these three cases, what you end up seeing is culpable homicide not amounting to murder, and finally in the 25th floor case, murder. Now this is again different in different countries. You have first degree murder, second degree murder, you call it different terminologies. But the point here is each of these is different, which is why you should get a different punishment. And what's important is that there was somebody 5,000 years ago talking about such things, and that's what's important. And so of course, if you're driving a car and you hit somebody by mistake and that person dies, it's an accidental death. You didn't plan to kill somebody. But on the other hand, if you drive a car into a crowd with the intention of causing maximum damage, then of course that's a different situation altogether. So the crime, the system of the law, the crime law, criminology law, criminal law would make a differentiation between these different type of scenarios, which is now when you understand why a police officer in the United States tries to restrain an aggressive person who is charged with a criminal offense. It's just a charge. The police are just investigating. The police officer puts his leg on that person's neck to restrain that person. And now this person dies after a few hours. So the question is, what the hell just happened? Now, if you were to charge this police officer with death due to negligence, which would have a lower burden of frame, you don't require a high burden to prove that case, then in that situation, based on the evidence, this officer can easily get 4 years, 5 years in prison. But if you're going to try to charge this officer on the offense of murder, well, it won't stick, because when that officer put his neck on that black suspect's neck, he really had no expectation that this person would die. You see the point over here. It's a very subtle point, but it's a very important point from a legal perspective, because as you may know, law is blind. Law doesn't go into emotions. What law is interested in is looking at the facts on the ground and what the realities are. So of course, in this scenario, you have this different concept of punishment. And well, the important point here is that this was already being discussed 5,000 years ago. And so that's very interesting for us. So this, of course, brings us to what would be the role of a lawyer in such a legal society and the way it sort of evolved. And this is something I'll be talking about in more detail as well. But the role of lawyers has been witnessed in society at least for the last um, 2000 years or so. So you already had lawyers in Greek times, in Roman times. Of course, they were not expressly known as lawyers, they were just influential people who could come before judges and talk about things. So the whole drafting and setting up of a legal infrastructure is very interesting to see from a legal perspective. A lot of specialized universities dealt with legal topics and the training of lawyers. And so what was earlier seen as just a mere social science evolved into a specific field which is now known as law. I mean, for the last 1000 years or so. And a lot of famous people in history have been lawyers, and I've given some examples here: Abraham Lincoln, Gandhi. So these are again something to be inspired with. I know it can be very, how would you say, easy to dismiss such situations nowadays. You look at Donald Trump and you think, well, you don't need to be a lawyer to be influential in society. You don't need to be super educated. Sometimes some of you may think that money talks and money is more important than anything else, but that's not always true. When I was a young lawyer, I fell into that trap as well, and I could always, already see how corruption can arise, even in societies where we think that corruption normally does not exist. And that is true whether you are in Asia or in Europe or anywhere else. But again, what's important, at least at your stage of life, is that you shouldn't get bogged down by those thoughts. And so it's my duty to sort of impress upon you the important aspects of law, the elements of law. And of course, societies go through all sorts of upheavals, but again, laws, can really help to pull things together. And of course, we have examples of societies where law has collapsed. And you could see, for example, in the case of a civil war in for example, Syria, or in many countries where you have complete breakdown of law and order, and life there is not fun. So again, law is very important. I have given some examples over here in the notes about different law aspects and things. Again, these are just some very simplistic examples I've picked up from the US point of view, which detail certain areas of thought. Since I'm an IP lawyer, of course, I talk about Sony case a lot. It's from 1984. But again, there are a lot of other cases. And if you look at these, they all outline certain things. For example, for a very long time, if a young woman was in a mental institution or was incapacitated due to mental disabilities, it was quite common to have the uterus of such women who were in institutional care to be removed. So can you imagine, the uterus of a young woman is removed because society felt that such people should not procreate, not have more children, or two, that being a young woman in such an institution, she will probably face abuse. So it's better to just remove the uterus and problem solved, then nobody gets pregnant and nobody asks questions. So again, these are sort of very strange issues that come up. And so if you look at the timeline of some of these cases, whether it is freedom of speech or the right to have liberties, these could be, for example, the freedom to undergo an abortion, or the freedom to access literature in the privacy of your house, which could also include pornography. So all of these have their basis in some of these aspects over here, some of these case laws. Again, segregation in racial context, interracial relationships, all of these have been dealt with over here, and you can see some of these cases. But more importantly, there are, of course, three men whose photos I have put up. And again, there are three distinct case studies. So number one, of course, is this person from Norway, Mr. Breivik, who murdered several hundred young people during a killing spree, bombing and using of firearms. And in this situation, of course, we would all agree that he's entitled to a fair trial, a free and fair trial, which is what he got. At that point of time, when the crimes were committed in Norway, you did not have the death penalty, it had been abolished. So a lot of people said, no, we should bring it back just for this particular person. But the court rightly held that no, you cannot have retrospective effect of criminal laws. And well, if there is no death penalty, then you cannot be charged with the offense of death. And you cannot change the law to bring in the death penalty again after the crime has been committed. So you all agree, we all agree that he's entitled to this. The second gentleman, of course, well, I don't know if you can call him that, but well, he is Osama bin Laden, and you know how his story went. He was hiding in this house, and the United States Special Forces went in and they shot him and they killed him. But nobody ever expected or imagined that he would be arrested, read out his Miranda rights. Sir, you have a right to remain silent, you have a right to an attorney. If you do not have an attorney, you will be provided one with the court of law, by the court of law, and things like that. So of course, they just went bang, bang, bang and shot him. So the question that arises is, well, we all say he's a terrorist, but did he get his opportunity to prove it in a court of law? And this again sort of brings out the issues. Now, as a lawyer, you see, you need to think separately. You're not a human being with an emotional context over here. What you are is a lawyer, a professional. And one of the hallmarks of a good lawyer is to possess the qualities of objectivity and detachment. So you have to be objective. This is the task. You can't be subjective about it. And detachment in the sense that you cannot carry your biases or your inherent feelings and try to let them influence you in this regard. No, you're not a judge, you're a lawyer. And of course, it is very important for you as a professional to ensure that justice should not only be done, but should also be seen to be done. So again, these are issues that come up. The third person is, of course, a rather interesting person. Many of you may not know him, so I put an article in Moodle after this lecture about him. He's Dominique Strauss-Kahn. He was this very influential French politician, and he was the head of the IMF, and he was really going out, great guns, doing amazing things. He had a bit of a nasty side about him, but all famous people do. Anyways, here's the story about him. He went to New York. He was in the hotel room, the most expensive room, and he saw this hotel maid, and he tried to sexually assault her. And he even achieved a bit of that. And so there is a video camera from the corridor. You can see her running away from him. Her clothes are torn. She went to the manager, yelling, saying that she was attacked by this person in the hotel room, a guest. By the time all of this got sorted out, the police were called. Dominique Strauss-Kahn just packed his bags and he was going to the airport. He got on the plane. He was supposed to fly back to France or somewhere, and then the plane was stopped and he was offloaded, and he was charged with sexual assault. Now this is what's interesting here from a legal viewpoint. This matter never really went to trial. You see, already, of course, he was denied bail, and that was a procedural part. But the prosecutor's office in New York were not very keen on prosecuting this man, because they felt that this woman, the accuser, was from a third world country. She had a shady background. She was a mother, unwed mother, single mom. She had a economic background which was quite poor, and her ex-boyfriend was a convicted drug dealer, and she had also let him use her bank accounts. So basically, the public prosecutor's office in New York felt that they had a weak case. So they never even took it to court. She never got to stand in court before a judge to say that, yes, this is the man, he assaulted me sexually, because that matter never went up to court. So again, I put up some of the information in that article. It's a news article. Well, she did separately file a lawsuit against him under civil law in a civil court, and then there were some undisclosed damages that were paid. So again, all of these three are examples of how the system works, and well, they're all quite recent examples in the last 10-15 years. So you can see the distinctions here, where one person who is charged with mass murder gets a free and fair trial. A second person charged with mass murder gets shot in the night by SEAL Team 9, yeah, and then his body is dumped somewhere, so we don't know. And the third person in this case over here, a very influential person who literally got away with the crime simply because, well, as he himself said, being so rich, why would he want to rape some poor woman like her when he can get anybody he wants? I mean, that was basically his defense. So you can see how the law has its flaws and it doesn't always work as optimally as we would like. So now, maybe since I have discussed a few heavy things here, I would like to now draw your attention to 3 articles that I have uploaded in the Moodle course as well under the lecture 1 subtopic. So general definitions and basic aspects. Now, I would like you to read these 3 articles. Well, they are a bit lengthy, but again, they're not from the exam point of view of any relevance. Rather, what I would like is for you to sort of get a broader picture about various elements. Now, the first article is from the 1990s, about 20 years old now, and it explores the role that law has played in the shaping of Silicon Valley. So some of these articles may seem a bit, heavy duty, but hey, you're law students, you're young, and you should be reading as much as possible. So, well, here's your chance. All right. Again, not from the exam point of view, but from developing into wholesome, good lawyers. So the first article regarding this American legal infrastructure in a particular state in the United States explores these options and activities. So we look at the intellectual property law scenario, then we look at competition law, antitrust as it's called in the United States. We also look at contract law and labor law. And so you get an idea about how all of these legal elements help to make society into what it is. So the law can either make society into a better place, or it can lead to ruin. So when you often wonder why are all these internet corporations based in the United States, or based in or around Stanford or Silicon Valley, then you can understand from this article how the law infrastructure is so important. There are 2 more articles that I've added up over here. One is regarding research which I had done with some colleagues, where we had compared Estonia with Finland. And here we are not only looking at the legal aspect, but also the social aspect. Remember, law is a science, but it comes under social sciences. And well, of course, social sciences, as some people would say, are not really a science. Real science would be natural sciences like law, chemistry, biology, zoology, botany, microbiology, physics, maths, things like that. And then, of course, you have social sciences, where we look at not only quantity but also quality. And then we have, legal studies that come in this framework. But it would be a mistake to completely cut away law from society. So, of course, this brings into the notice of certain things. We need to now look at economics, the principles that go behind economics, the principles that bind law and economics, and of course, the role that they play within a social system. And so here are some articles about it. Now I've compared Estonia with Finland in one of these articles, and we have looked at the legal dimension, the social dimension, when we look at research and development and innovation and the legal policies that go into it, there are already a lot of tensions that would be apparent with respect to state aid law, with respect to competition law. Some of these articles are dated, so some of the information has changed a bit. But again, you can see in this article how Finland has evolved, and Finnish industries from the 50s onwards evolved. And again, of course, what role the patent system played in all of this. And again, when you talk about patents, you of course have to look at research and development, which would then be done by private individuals, entities, enterprises, or which are funded by the state through universities. And so you see what's been going on in the University of Helsinki, Aalto, Turku, etc. So again, the idea is to draw comparisons using intellectual property law framework and competition law framework in the context of state aid, and to see how Finland has achieved certain criteria and what can be done by Estonia in that regard. The underlying feature in these articles is, of course, law, and what role can law play in facilitating certain things. Those of you who are from Estonia would know, for example, that Estonian Air had to shut down because they were receiving a lot of state aid from the government. And at that point of time, the European Commission said that, the government should not be in the business of flying planes. But now things have changed, and you see, for example, Finnair and Lufthansa are getting millions of euros in aid from the respective governments. And again, this is an exception. So again, the point here is that law plays a big role in shaping society, and the sooner you get the bigger picture, the better it will be for all of you. Continuing with this, well, another article that we had written, I and some of my colleagues, was a comparison of Estonia with Germany. Again, we are looking at patents, so IPR, intellectual property laws. Then education policy, of course, is a more of a social phenomenon. But RDI, research, development and innovation, and the expenditure policy, which would dictate how the state wants to propel society and technology development in a particular manner. And so again, you see in this article what Estonia can learn from the things that Germany has achieved. So these are the 3 articles I would like you to read, along with, of course, this little news article on Dominique Strauss-Kahn. And I hope at the end of this, you already get to see the picture over here. There is the legal aspect. We have looked at it in lecture 1. The history of various laws, not a very detailed history, but just in passing, we have looked at something from 5,000 years onwards. And so we have seen how different legal systems and different legal thoughts have evolved just by looking at the examples of Babylon and Greece. And then again, I have then sort of outlined some more recent examples of how law influences the direction that society takes. So you see, for example, in Tallinn, and this is of course something that we have been researching a lot as well, there's a lot of information that has been out there. You can't just simply recreate universities or Silicon Valleys by building a house and painting it yellow, right? I mean, or green or whatever. There's a full infrastructure that plays a role in this, and this infrastructure is highly dependent on laws. Since we are in the European Union, of course, you cannot see things in a compartmentalized way. There is law, and it has its own subdivisions, different types of laws. Property laws, property law then evolves into something that is tangible property, immovable property, movable property, like a pen or something, or a phone. And then you have intangible property, which would then be trademarks, patents, copyrights, designs. And then it evolves into, for example, data, and how do you deal with data. So again, data then becomes something that is covered under copyright law. Then later it comes under the GDPR. It comes under different aspects like trade secrets. So you have a lot of the subdivision within law itself. But these laws also interact and collide with other laws. So you have the European Union law system in place. It's very important in the European Union that this entity should continue. And of course, that means that Finland and Estonia and France should not be fighting, but should be acting together. And this is a problem because you then also have certain laws like competition law in the EU context, which can be different in different times and different places. So not only are these relevant, but you also have social development. Like for example, in the case of Finland, yes, you would say Finland is a very developed country, but maybe that's more relevant for the south of Finland. The more north you go, suddenly it's not the same situation everywhere. So it's the same also in Estonia, for example. So North Estonia, Tallinn does very well. And then as you go down in the center, Rapla, Mau sort of just empties out. And then maybe you have some pockets in Tartu, Pärnu, things like that. So again, how can you have the same legal framework and the same legal requirements in these areas together? So if you were to then compare it with, say, European Union, you can see how there are differences and different approaches in the EU context as well. And so when we look at the general definitions and basic aspects, I hope for the rest of this course you keep in mind the legal structure, the economic aspect, the social structure, and of course the different legal systems that are bound together, not only with each other, but also with very different aspects which play an important role. So for example, maybe just before I end this lecture, to talk about one example would be that state aid is restricted normally. And so if the government of Finland gives 1 million euros to Nokia to develop a new software, of course that would not be acceptable, because in a free market system, Nokia, Apple, Samsung, Huawei, all should be able to compete given the right circumstances. But if the Finnish government was to give 1 million euros grant to Aalto University, and they were to develop a software which they would then give to Nokia, the question would arise, on what grounds is this technology made available to Nokia? And already you can see over here that if this technology is given by Aalto University to Nokia for free or for a very small sum of money, then this would be an abuse of state aid rules. But if Aalto University was to license out this technology to Nokia at market rates, then it would be a compliance with the legal system. So these are some of the things that you should be careful about, and hopefully these articles will help you to get into that frame of mind. Next time, I'll be talking about the philosophy and classification of law, and in that I'll be also discussing some aspects about procedural law and how they play a very important role. So until that time, well, I'll bid you farewell and thank you for attending this video lecture course, and I hope to see you soon next week. Goodbye.